On this morning's docket. Case number 105297, State of Kansas v. Bolze-Sann.
Good morning, I'm Rick Kittle. I represent the appellant, Miss Michelle Bolze-Sann, and I'd like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. The court will recall that in this case, Michelle was found guilty of involuntary manslaughter and aggravated endangering a child. This is the case in which a defendant had a daycare business in her home. She placed an infant child on a normal bed and checked on the child a couple times without incident, and then when she went back the last time, she discovered the child had been wedged between the footboard and the mattress of the bed and was not conscious, and the child could not be resuscitated. In that case, it was determined that the child died of positional asphyxia. The state's theory of the case here was that because there is a Kansas administrative regulation, 28.4.116, that deals with daycare facilities and prescribes the manner in which these daycares can provide naps for the children that are there, that Michelle was aware of this regulation and that she violated the regulation. She must have acted recklessly and or committed the crime of aggravated child endangerment. And because a child died here, she's also charged with involuntary manslaughter. The first issue in the brief of the appellant here is a challenge to the sufficiency of the evidence of both of these crimes. We submit that the evidence here did not show that she acted recklessly. In the district court, this issue was basically raised by the defense, citing a case called State v. Stallhut, which is an unpublished opinion of the Court of Appeals, which deals with the same administrative regulation. And in Stallhut, it's a very similar situation. Daycare facility, the woman had put an infant child down on a waterbed, later checked on the child. The child's head had become wedged between the side rail of the waterbed and the mattress, and the child had died. The Court of Appeals in Stallhut examined the purpose of the administrative regulation and determined that its purpose was to protect infants from the dangers of sleeping on normal beds. But the evidence, I think, is what's important in the Stallhut case. Stallhut indicated that there are 3 ways that a child might be asphyxiated in these circumstances. One is what happened in Stallhut, where the child's nose and mouth are occluded because they become wedged. The child cannot take in air, and the child asphyxiates. The second way is the way that happened apparently in the instant case, where the child's breathing is compromised because the body, the torso, has become wedged between objects. Chest can't expand, the child can't take in air. The third way is that the area around the child's mouth and nose is somehow constrained in a way that there's no free flow of fresh air. The child inhales its own carbon dioxide and asphyxiates in that manner. What's important is that these methods of asphyxiation, particularly the third method, are not peculiar to water beds and normal beds. These types of asphyxiation can also occur in approved playpens or cribs, just as they could on a normal bed. And that's why the Court of Appeals found that the state in these situations has to prove, in Stallhut, the Court of Appeals found that the state had to prove that the defendant intentionally placed the child on the bed and that doing so was unreasonable because she knew or should have known of the danger of asphyxiation. I think the problem here is that if you look at this regulation, its purpose is not to prevent asphyxiation. It seems that the evidence in this case indicates that the purpose for not putting a child on a bed, on a flat surface or a water bed, but putting the child in a playpen or a crib is to prevent the child from rolling onto the floor and being kicked or trampled and injured that way, or injured in a fall. I mean, I think it's a matter of common sense if you just look at the physical configuration of a normal bed as opposed to a playpen or a crib. the playpen or the crib have high walls to prevent a child of that age from getting out, from rolling onto the floor, from somehow getting out. And so that's why we have that regulation.
Mr. Kittle, the problem I have is reconciling your argument with a statement we've made in many cases, which is that for conduct to be reckless, the perpetrator must merely know that he or she is putting others in danger, not that he or she foresee the particular harm that causes the injury.
Well,
aren't you arguing that for the state to prove its case, it had to prove that the defendant here knew of the specific risk of asphyxiation?
Well, I think that's part of the argument, but I also think part of this argument is Michelle would not have known that she was actually putting the child in danger from just what she did.
Well, why not when a regulation tells you that you're putting a child in danger? I mean, in essence, is saying you're putting a child in danger by not putting them in a crib or playpen. Now, it may be that the harm that is being attempted to prevent is something different, but don't we start with the assumption that
That's true.
by violating the regulation, we knew she was putting that child in danger of some sort?
I don't think the language of the regulation is specific as you're making it out to be about specific dangers or any danger at all. It's just that these are the prescribed methods that are in the regulation. And that's one reason why I think the actual means of death here would come into play here, because if the regulation isn't specific enough, how is she supposed to know, well, if it's falling off the bed or if it's asphyxiation death? It doesn't make any difference. She wouldn't have been put on notice based upon the language of that regulation that the dangers associated with, that there were any dangers associated, certainly dangers associated with asphyxiation in this case.
And Justice Lugar's question is that all of our previous cases on recklessness indicate that's all that you need to know, is that there's a danger to be avoided.
Well, yeah, and I'm saying that the question of foreseeability comes anytime you have recklessness where you have an imminent danger and there has to be a conscious disregard of that danger. The defendant, in order to prove that, the defendant must have some knowledge that there is an actual danger associated with the act.
What about the testimony Zachary's mother explained to the defendant that his mobility had rapidly advanced and it would not be safe for him to nap in an adult bed? The defendant again assured the parents that she would never place an infant in an adult bed for naps. Anything to be made of that in terms of recognizing that there was a danger and disregarding it?
Perhaps, but that's not, I don't think that's the theory that was advanced by the state here. The state's theory was based upon the administrative regulation. I guess I would, what if we, putting aside for a minute the regulation and the daycare, what if this had just been Michelle Bolze-Sann, if she had an infant of her own and she had done this same act, put a child on a bed, and the same result had happened? The question I have is, would she have been charged with a crime under those circumstances? There wouldn't have been any regulation at issue, and it would have just been, would she have been able to foresee a danger? Was there an actual danger? Shouldn't she be required to have some reasonable knowledge that there is a danger associated with her act? And I don't think, certainly it seems less likely that if that had been the situation in this case, that she would have been charged with an offense.
Isn't the reason she put the pillows around the baby was to prevent danger?
To prevent the evidence at trial was to prevent the child from falling off the bed.
That's the safety to protect the safety of the child.
Right, but that's not the cause of death in this case, and I think that's an important consideration here.
Why?
Because
when it's recklessness and we're talking about just the safety of the child.
Because the theory of the state here is based on that regulation. If that regulation exists to prevent the child from falling off the bed, then she didn't disregard that danger.
Well, what Justice Miles is saying, why isn't that a recognition of the risk or of the danger? The fact that she took steps to protect against the danger, recognize that it exists. And that's what we're talking about, is
Right,
to
well,
know
yeah.
about a risk of danger and disregarding it.
I guess the offshoot of that is that it doesn't make any difference how the child dies. If there is some sort of danger associated with the act, even if it's something that is completely unexpected, could not be foreseen, then somehow she would be guilty of an act of a crime of recklessness associated with it. I think that's taking that too far. I think the danger has to be something that can be reasonably foreseen by the defendant. And in this case, there's no reason based upon the language of the regulation or the actual measures that she took that she saw the danger that actually befell
What
the child.
about, and I thought during, part of the evidence in this case was that during the licensing process, there was some discussion with the state or the regulators and your client regarding infants under 18 months of age in playpens and cribs and those kinds of things. And there was a discussion about that, and that was checked off that she understood that was a requirement for napping
Right.
and rest. What about that? Doesn't that come into play here as
Well,
far
I
as her
think
knowledge?
the problem there is the same. You know, this inspector came around
Right.
and they went over the regulation.
Right.
She was aware of it. She clearly violated it. We're not disputing that. The question here, does what was said to her by the inspector, or does the language of the regulation actually provide her with enough information to know what she is, the purpose of the regulation itself, and what danger exists from that? And I submit that it doesn't in this case.
Are you or
Go ahead. Mr. Hill, it seems like to me that what you're arguing is, you're not arguing that she wasn't aware of the danger that the regulation was designed to prevent or from coming to pass, because she knew about the reg, and in fact her behavior indicates that she tried to protect against the danger the reg was designed to avoid. That is the falling off the bed scenario.
Right.
So it's really the disregard part that you're arguing is insufficient, not the realization.
Well,
but the
that's
disregard.
that's part of the argument too. Part of the argument I made in my brief is that recklessness requires that there be an imminent danger, that there be a conscious disregard of that danger. And what I'm saying is she did take actions to prevent what she did recognize might be a danger. I'm not saying that that's based upon her understanding of the regulation, because I don't think the regulation is actually specific as to whatever dangers might occur. But she did apparently recognize that there might be a danger that the child could roll off a bed. She didn't disregard that danger is what I'm saying. And if she didn't disregard the danger, then it's not recklessness. Also, I'm arguing this isn't an imminent danger. Recklessness requires that there be a conscious disregard of an imminent danger. The facts that I'm running into my rebuttal time, if I may go ahead and use a little bit of that, please, Your Honor. The facts indicate that at one point she did have 2 cribs, that she was caring for 2 infants, that one of the cribs broke, and so she was alternating days, putting a child on the bed, and then switching the next day, putting that child in the crib. But that went on for a period of time. My point would be, it went on without incident, and therefore, that's evidence indicating that there wasn't imminent danger. The danger was not close at hand. And therefore, if there's not imminent danger, there is no recklessness, because there's no imminent danger to disregard.
if the danger is to prevent the child from being able to move out of the sleep area, isn't that the danger that happened here?
Well, I don't know. That's bringing up a whole new set of terms, and I don't know that was ever used in the record, and that's not the term I'm using. It's either being asphyxiated or falling off the bed.
And in essence, didn't he fall off the mattress and became trapped?
Well, he didn't fall all the way off of the bed, for one thing, and then the question is, the cause of death was not being trampled, which is the understanding that we have from the record in Stallhead is what the purpose of that regulation is. Falling off the bed and being kicked or being trampled or being injured in the fall from the bed.
Any further presentation?
No, Your Honor.
Any more questions? Thank you, counsel.
Good morning, may it please the court. The state appears by Assistant District Attorney Jody Litvin. The state's position here is that we presented sufficient evidence to convict of involuntary manslaughter and of aggravated endangering a child. As we've hit on, there was evidence from both of the parents here specifically telling the defendant not to place their child on a bed for a nap or at any time. So she was aware of the increased mobility of the child, and as recent as a month before the incident happened, reassured the parents that she did not place the child on a bed to nap. In addition to that, we have evidence that she did place a ring of blankets and pillows around the child in order to prevent some sort of danger. That the inference, taken in the light most favorable to the state here, is that she recognized some sort of danger. And I think it's important here to...
Is the critical part of this that she's a licensed daycare provider? I'm wondering here, there are probably at this very moment hundreds of 6-month-old or under, maybe a little older, that are in a bed, asleep, with pillows around them, or maybe not with pillows around them, in a caretaker's home, be it a parent or somewhere else. Are they committing aggravated endangering a child as we speak?
I think that the regulation goes to prove her recklessness here, but I don't think it's the only evidence that we have of aggravated endangering of a child. So I think there's more evidence here, and if in those cases there was evidence that the parent had been, or the provider had been told not to place the child on a bed, then yeah, I think there would be enough evidence, even without the regulation, to prove aggravated endangering a child.
So the difference is the knowledge that the provider has.
Yes, that would be my position.
Yeah. Same is true then with parents?
There's an additional duty on
Right.
daycare providers. So I see what you're asking here. I don't know that we would charge it, but there could be sufficient evidence of it, I think, without the daycare provider part. I don't think it's important here that the daycare provider had to know the specific cause of death was foreseeable, because I think, as this court has noted, under recklessness, you just have to have a realization of the imminence of danger and a disregard of that.
Let me take you back to defendant's actions of putting blankets and pillows around the child. You characterize that as an awareness of danger. Why isn't it also, doesn't it negate her conscious disregard of that danger? If she took steps to prevent the danger, I mean, why didn't that cut both ways for you on the two different elements that we're talking about?
I think it could, but I think that if we view it in the light most favorable to the state, the inference goes to us, and that inference is that she disregarded that danger. The jury could have bought that interpretation and could have found, she didn't disregard it. She was absolutely trying to keep the baby safe, but they didn't. And I think we have to look at it in our favor now, at this point in the game. And also, I don't think it takes away the fact that it was imminent danger because she did something to try and protect the child. It doesn't make the danger any less imminent. Every time she put a child on the bed, that danger was there. So I don't think the fact that she had done it before and nothing had happened takes away that imminent danger. I don't think I had any other presentation. We would just request that the convictions be affirmed here, if there's no other questions.
Any more questions? Thank you, counsel.
Thank you.
You reserve 3 minutes for rebuttal.
Thank you. Justice Rosen brings up a good point. That's one of the things I wanted to mention and did not on my first. I imagine, as Justice Rosen said, there are parents all over this state who because they don't have a crib, don't have a playpen, are putting their children down to nap on beds. And they may or may not be taking the measures that Michelle took to, putting a ring of blankets and pillows around that child. Are they guilty of these crimes? Or at least are they guilty of aggravated child endangerment if they just do that simple act? Counsel says, well, they might be, but I don't know if we'd charge that. Well, I'd argue it doesn't make any difference if there's a regulation in place or not, because the act is the same. The result could be exactly the same. And, parents may have their own body of knowledge about what is proper and how you're supposed to put children down to nap. But ultimately, I think what we have here is just an accident. It's a tragic accident. It's all the more tragic because it's a small child involved. It's all the more tragic because the child that died here was someone who was in the care of a daycare provider. But, parents, every day, we send school children home from school, walking across streets unattended. There's some measure of a risk associated with those type of acts. And it's, quite possible that a child might be struck by a passing car. Is that something that's foreseeable? Is it something that's likely? I don't know, but I don't think that would be a criminal act if something like that happened. A parent wouldn't be charged with a crime based upon that. And I think the same thing holds true here. Michelle didn't see that this was going to happen. She didn't have an understanding that this was going to happen. She didn't have an understanding based upon the language of the regulation or anything that the inspector told her.
But what about what the parents told her? They said, don't do this, and she said, I won't.
That's true.
And that's got to play into the calculus here. And, I think that's I just think it disproves what you're arguing.
And I think that's why this goes back to the question of what does the statute mean? What does it provide? Even if they said told her this child is becoming more mobile, don't put her on the bed, and she went ahead and did that, I still think there's a question of foreseeability that exists here.
The foreseeability would be that the child is going to move, and we know children move sometimes into unsafe places. And the other thing we haven't talked about at all during these arguments is the child is crying for 10 or 15 minutes, and she's not doing anything about it, not even checking on the child.
Well, is that a crime in itself? I don't know. The same thing could apply to parents. If you put a child.
But it all adds up. You can't try to silo one fact in the evaluation that a jury or that an appellate court has to do in looking at these facts. You take them all in together. You have regulations, you've got instructions, you've got parents' warnings, you've got assurances that you won't do it, and then you got the baby crying, and then the baby ends up dead.
And I guess what I'm saying is even if you take all those things into consideration together, they don't rise to the level that she had a conscious disregard of a danger, that she actually knew the specific danger, or even maybe the general danger that caused the child's death. And so, based upon that, I would argue that the state hasn't produced sufficient evidence here to prove the crimes in which she was convicted.
Counsel, earlier you described this as an accident. Did I understand you correctly?
That's what I said.
And by choice of that word, it would suggest to me that you're saying there would not even be recourse in the civil courts for the parents here. The defense would be, it's an accident, nobody's responsible, there was no duty, there's no breach of a duty, no causation, we're just done. Is that what you really meant to say?
Well, I didn't mean to imply that. Maybe my use of the word accident wasn't the best choice. What I'm saying is this is not something that she should be convicted of a criminal offense based upon because of I'm not arguing that the regulation is vague, but it doesn't give specific measures or it doesn't give specificity as to what the specific danger is or why it even exists. And without something more, I just don't see that, how she can be held responsible for something that she couldn't have reasonably foreseen.
Any more questions?
I'd like to shift to a different issue on the question from the jury and the way that was handled. Can you distinguish the briefing in this case from the briefing in Verser or Bowen, or do we reach the same result here that we did in those cases?
Well, I don't know. I guess no. You're probably going to have to reach the same. It's the same situation. It's the same situation. A question is asked during deliberation. A written note is used to respond to the jury's question. The point I've made all along in all of these issues, Verser was my case, and counsel filed a 609 letter. I think maybe one or two of those cases were my cases as well. The problem as I see it is that this denies the defendant's right to be present at all critical stages of a trial. That has been historically viewed for harmless error, but it also denies the defendant's right to have the judge present at a critical stage of the trial when the information is being given to the jury. And that has not been viewed as harmless error. It's been viewed as structural error analysis. And so my argument is the same. The result may be the same thing found in Verser, but I'm maintaining that argument that this should, at least part of that argument should not be viewed for harmless error because it's more important than that. The defendant should have a right and should be entitled to have the judge present at all critical stages of the trial. And when a note is used to respond to a jury's question, that doesn't happen.
Counsel, one factual question. According to my notes, your client checked on Zachary at the latest at 12:40, and that's when she discovered he had moved within the ring of pillows.
Right.
And what was the time when she actually found him wedged,
Your Honor,
unresponsive? Is there a record of that?
I don't recall that there's any reference to that in the record. What I do recall is that it was some point after 2 hours after she put him down that he was discovered wedged between the footboard and the mattress of the bed. But I don't recall there actually being a specific time set in the record for that. But it was a little more than 2 hours, as I understand it from the record.
Very well, thank you. Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement.